Dear students, after studying this module, you shall be able to know about the contemporary statutes in India related to digital forensics and evidences, the laws provided in the specific laws besides the penal law, and various sanctions provided under the special laws. Computer forensics is the application of science and engineering to the legal problem of digital evidence. It is a blend of science and law. Acquisition of evidence is both a legal and technical problem. In fact, these two facets are irrevocably related to each other. The law stipulates what can be seized, under what conditions, from whom and from where it may be seized. The determination of what a particular piece of digital evidence is requires its examination. The increase of computers and the impact of information technology in the society and the storage of information in digital form required consistent amendments to Indian law to embrace the provisions regarding the increase of digital evidence. Law enforcement agencies face a new challenge in dealing with cybercrimes. Criminal activities are being committed and the evidence of these activities is documented in electronic forms. Moreover, crimes are being committed in cyberspace. Evidence in these crimes is virtually always recorded in digital approach. It is essential that computer security professionals should be cognizant of some of the requirements of the legal system and comprehends the emerging field of computer forensics. The certainty of the information phase is having a substantial impact on the legal establishment. One more important area in which this is being felt is that of the procurement, authentication, evaluation and legal admissibility of information stored on magnetic and other media. This information can be stated as digital evidence. Information Technology Act provides legal recognition for transactions carried out by means of electronic data transaction and other means of electronic communication, which encompasses the use of substitutes to paper-based approaches of communication and storage of information. Now we shall deal with the Indian Penal Code, Section 167, Public Servant framing an incorrect document with intent to cause injury. Whoever being a public servant and being as such public servant charged with the preparation or translation of any document frames or translates that document in a manner which he knows or believes to be incorrect, intending thereby to cause or knowing it to be likely that he may thereby cause injury to any person, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Next is section 292, sale etc. of obscene books etc. For the purposes of subsection 2, a book, pamphlet, paper, writing, drawing, painting, representation, figure or any other object shall be deemed to be obscene if it is lascivious or appeals to the prurient interest, or if its effect or where it comprises 2 or more distinct items, the effect of any one of its items is, if taken as a whole, such as to tend to deprave and corrupt person who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it. Whoever sells, lets to hire, distributes, publicly exhibits or in any manner puts into circulation or for purposes of sale, hire, distribution, public exhibition or circulation, makes, produces or has in his possession any obscene book, pamphlet, paper, drawing, painting, representation or figure or any other obscene object whatsoever, or imports, exports or conveys any obscene object for any of the purposes aforesaid, or knowing or having reason to believe that such object will be sold, let to hire, distributed or publicly exhibited or in any manner put into circulation, or takes part in or receives profits from any business in the course of which he knows or has reason to believe that any such obscene objects are for any of the purposes aforesaid made, produced, purchased, kept, imported, exported, conveyed, publicly exhibited, or in any manner put into circulation or advertises or makes known by any means whatsoever that any person is engaged or is ready to engage in any act which is an offence under this section, or that any such obscene object can be procured from or through any person, or offers or attempts to do any act which is an offence under this section, shall be punished on first conviction with imprisonment of either description for a term which may extend to 2 years and with fine which may extend to 2,000 rupees, and in the event of a second or subsequent conviction with imprisonment of either description for a term which may extend to 5 years and also with fine which may extend to 5,000 rupees. Next is section 354C. It is regarding Vagarism. Whoever watches or captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator shall be punished on first conviction with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 3 years, and shall also be liable to fine, and be punished on a second or subsequent conviction with imprisonment of either description for a term which shall not be less than 3 years, but which may extend to 7 years, and shall also be liable to fine. Section 354D, Stalking. Whoever follows a person and contacts or attempts to contact such person to foster personal interaction repeatedly, despite a clear indication of disinterest by such person, or whoever monitors the use of a person of the internet, email, or any other form of electronic communication, or watches or spies on a person in a manner that results in a fear of violence or serious alarm or distress in the mind of such person, or interferes with the mental peace of such person, commits the offence of stalking. Whoever commits the offence of stalking shall be punished with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 3 years, and shall also be liable to fine. Next is section 500, punishment for defamation. Whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, or with fine, or with both. Next is Indian Evidence Act. Section 22A, when oral admissions as to contents of electronic records are relevant. Oral admissions as to the contents of electronic records are not relevant unless the genuineness of the electronic record produced is in question. Next is section 45A, opinion of examiner of electronic evidence. When in a proceeding the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79A of Information Technology Act of 2000, 21 of 2000 is a relevant fact. Next is section 65B, admissibility of electronic records. Notwithstanding anything contained in this act, any information contained in any electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer, hereinafter referred to as the computer output, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without further proof or production of the original. as evidence of any contents of the original or of any fact stated therein of which direct evidence would be admissible. The conditions referred to in subsection 1 in respect of a computer output shall be the following, namely, the computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purposes of any activities regularly carried on over that period by the person having lawful control over the use of the computer. During the said period, information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in ordinary course of the said activities. Throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was out of operation during that part of the period was not such as to affect the electronic record or the accuracy of its contents, and the information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of the said activities, where over any period the function of storing or processing information for the purposes of any activities regularly carried on over that period as mentioned in clause A of subsection 2 was regularly performed by computers, whether A, by a combination of computers operating over that period, or B, by different computers operating in succession over that period, or C, by different combinations of computers operating in succession over that period, or D, in any other manner involving the successive operation over that period in whatever order of one or more computers and one or more combination of computers. All the computers used for that purpose during that period shall be treated for the purpose of this section as constituting a single computer, and references in this section to a computer shall be constructed accordingly. Fourth, in any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, A, identifying the electronic record containing the statement and describing the manner in which it was produced. B, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer. C, dealing with any of the matters to which the conditions mentioned in subsection 2 relate, and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate, and for the purposes of this subsection it shall be sufficient for a matter to be stated to be the best of the knowledge and belief of the person stating it. Fifth, for the purposes of this section, information shall be taken to be supplied to a computer if it is supplied thereto in any appropriate form, and whether it is to be supplied directly or with or without human intervention by means of any appropriate equipment. B, whether in the course of activities carried on by any official, information is supplied with a view to its being stored or processed for the purposes of those activities by a computer operated otherwise than in the course of those activities. That information, if duly supplied to that computer, shall be taken to be supplied to it in the course of those activities. C, a computer output shall be taken to have been produced by a computer, whether it was produced by it directly or with or without human intervention by means of any appropriate equipment. Next is Information and Technology Act. Section 43, penalty for damage to computer, computer system, etc. If any person without permission of the owner or any other person who is in charge of a computer, computer system or computer network, A. assess or secures access to such computer, computer system or computer network, B. downloads, copies or extracts any data, computer database or information from such computer, computer system or computer network, including information or data held or stored in any removable storage medium. C. introduces or causes to be introduced any computer contaminant or computer virus into any computer, computer system or computer network. D. damages or causes to be damaged any computer, computer system or computer network, data, computer database or any other programs residing in such computer, computer system or computer network. E. disrupts or causes disruption of any computer, computer system or computer network. F. denies or causes the denial of access to any person authorized to access any computer, computer system or computer network by any means. G. provides any assistance to any person to facilitate access to a computer, computer system or computer network in contravention of the provisions of this Act, rules or regulations made thereunder. H. charges the services availed of by a person to the account of another person by tampering with or manipulating any computer, computer system or computer network. He shall be liable to pay damages by way of compensation not exceeding 1 crore rupees to the person so affected. Section 65, tampering with computer source documents. Whoever knowingly or intentionally conceals, destroys or alters or intentionally or knowingly causes another to conceal, destroy or alter any computer source code used for a computer, computer program, computer system or computer network when the computer source code is required to be kept or maintained by law for the time being in force, shall be punishable with imprisonment up to 3 years or with fine which may extend up to 2 lakh rupees or with both. Next is section 66, hacking with computer system. Whoever with the intent to cause or knowing that he is likely to cause wrongful loss or damage to the public or any person destroys or deletes or alters any information residing in a computer resource or diminishes its value or utility or affects it injuriously by any means commits hacking. Whoever commits hacking shall be punished with imprisonment up to 3 years or with fine which may extend up to 2 lakhs or with both. Next is section 67, publishing of information which is obscene in electronic form. Whoever publishes or transmits or causes to be published in the electronic form any material which is lascivious or if its effect is such as to tend to deprave and corrupt persons who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it, shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 1 lakh rupees, and in the event of a second or subsequent conviction with imprisonment of either description for a term which may extend to 10 years and also with fine which may extend to 2 lakh rupees. We shall end this module with the summary. Section 167 of Indian Penal Code, it deals with public servant framing an incorrect document with intent to cause injury. Section 292 of Indian Penal Code, it is for the sale etc. of obscene books etc. Section 354C of Indian Penal Code deals with Vagarism. Section 354D of Indian Penal Code deals with stalking. Section 500 of Indian Penal Code deals with the punishment for defamation. Section 45A of Indian Evidence Act deals with the opinion of examiner of electronic evidence. Section 22A of Indian Evidence Act deals when oral admissions as to contents of electronic records are relevant. Section 65B of Indian Evidence Act, it deals with admissibility of electronic records. Section 43 of Information and Technology Act, it deals with penalty for damage to computer system, etc. Section 65 of Information and Technology Act deals with tampering with computer source documents. Section 66 of Information and Technology Act deals with hacking with computer system. And finally, Section 67 of Information and Technology Act deals with the publishing of information which is obscene in electronic form.